Hello everyone, welcome back to my YouTube channel Laws on Point. This is Adv.suman pathak. In my previous video, I spoke about what are background checks, how a background check is done in India, and government initiatives for aiding employers. The video would be linked on the I button above. Apart from that, in today's video, I would be discussing about what are you required to disclose, consequences of non-disclosure of information, effect of past or pendency of criminal or civil case, or effect of F.I.R on employment or job or career. So stay tuned. What are the information that are required to be disclosed? Now, this disclosure of information would depend upon the nature of job. For certain kind of job, disclosure of information related to crime might not be a big deal, but for certain job, it is required for transparency and trust of the employer. At times, it might not be necessary to reveal any past case if it did not result in conviction, while it might be necessary in other instances. Well, in my opinion, the best option would be to disclose all the information to your employer in cases of any past or pending criminal or civil cases against you. If the employer finds out that the candidate have disclosed incorrect or misleading information or has suppressed any information, then in that case, the employer can legally take action against the candidate. There was this case of Aftar Singh versus Union of India where 3 judges bench of Supreme Court gave guidelines for the employers regarding while dealing with cases related to submission or suppression of information by employee or candidate in the verification form related to prosecution, pendency of cases in court. So the guidelines were as follows. Whether before or after entering into service, the information given to the employer by the candidate related to acquittal, conviction, arrest or pendency in the court should be true, and no information should be suppressed or false informationing should be done in the documents. In a situation where the candidate during filling the application or verification form suppresses any information related to involvement of criminal cases where conviction or acquittal has already been recorded and such fact later comes to the knowledge of employer, then in that situation, employer can legally cancel the candidature or terminate service of the employee. In previous point, I spoke about conviction. Now, the question can arise here is, what has to be done in the cases of acquittal? So in this case, if the acquittal is being recorded on a technical ground, it is upon the employer to decide and see all the relevant facts and then consider and think whether the employee is right for the company or not. There are multiple situations such as in a case where fact has truthfully been declared in the character verification form by the candidate regarding pendency or ongoing cases in the court. In that case, it's upon the discretion of employer whether to select that particular candidate or not. There can be another case where the candidate has suppressed any information related to multiple pending of cases. So in this situation, it's upon employer to terminate the candidature or terminate the employee from the company. As we all know, government jobs in India are preferred due to the perks and respect the position may bring. For a government job, background verification is one of the important aspects. Having a case registered against one might bring a negative impact on the application. Like I said in my previous video regarding government job, the background verification may also include a verification record from district magistrate or police. So there are 2 types of charges which can be framed against a person, civil case or criminal case. Talking about the civil cases, generally civil charges do not affect the position in government job. However, if the civil charges are grave in nature or involves moral turpitude, then definitely it will have impact on one's career or job prospect. So as per the law, If the government employee spends more than 48 hours in police custody, he would be suspended from the post. If the employee has certain charges framed against him related to dowry or dowry death, in that case, even if he has not spent time in police custody, still he would be suspended from the job. There was a landmark case of Ajay Kumar Chaudhary versus Union of India, where it was held that framing of charges and formally informing about the charges is an important aspect. So, if this step has not been taken immediately, firstly, it will affect the right of speedy trial, and secondly, the suspension of the employer gets extended. So, taking that into consideration, Supreme Court gave a ruling that any government employee should not be suspended for more than 3 months before he has been formally informed about the charges framed against him. Till now we discussed about public sector. Now if we talk about private sector, it would depend upon the nature of job and the kind of offense done by the employee or the candidate. So the private sector takes its own measures. They have their own policies to deal with such kind of candidate with the criminal records. If we talk about civil cases, even that would not have a much impact on one's career, but then it would definitely bring a financial burden or affect the credit score of the employee. Merely registration of F.I.R. will not have an effect on employment. For this, proceeding must be started in court or the person must be convicted of the offence. In cases of registered F.I.R., the best option is to institute proceedings to quash it in court under section 483 of CRPC. Next, if we talk about the applicants who want to work abroad and there are any pending criminal records against them, then in that case, under section 6(2) of Passport Act 1967, the passport authority can refuse a foreign visa if it is found that the applicant in preceding 5 years have been convicted of an offence of moral turpitude and been sentenced to more than 2 years imprisonment and criminal proceedings are pending against them in India. There can be a case where a summon to the court or warrant for arrest or orders prohibiting departure from India has been issued against him. So that's all for today's video. In part 3 of the video, I'll be talking about termination of employment, ground for termination and rights of terminated employees. I have listed the link of part 1 of the video series in the description box below. For any doubt or queries, please write in the comment box below and I'll be answering the queries very soon. Till then, stay healthy, be at home.